a Congress spokesperson, I understand, will have his fundamentals as far as secularism completely muddled. I have no doubts about it. No wonder we are where we are in terms of the legislation continuing to stand. Now, the point Dr. Swami made with respect to Mr. Tushar Mehta's submission is bang on the point, which is absolutely right. Because you see, as far as Ram Janmabhoomi judgment is concerned, one of the arguments that we have also raised and others have raised is that there was no occasion for the Supreme Court to deal with the Places of Worship Act in the context of Ram Janmabhoomi because that specific dispute was excluded from the scope of the legislation. So why will you discuss the legislation? When you discuss something that has got no relevance to the issue at hand, it is known as obiter dicta, meaning thereby it has no binding value. If you read Justice D.V. Sharma's judgment, and I've written a two-part piece on this in the New Indian Express and several other places immediately after the pronouncement of the verdict, Justice D.V. Sharma did not make a reference to the Places of Worship Act whatsoever. In fact, as part of his discussion on whether fundamental rights can be asserted by way of civil suits, he was extracting a 1995 judgment of the three-judgment of the Supreme Court, where there was a discussion on the Places of Worship Act. The Supreme Court mistakes this for a reference by Justice D.V. Sharma, makes that the pretext for a discussion of the Places of Worship Act, and then goes on to write 10 pages on how the Places of Worship Act effectively protects secularism, which happens to be the basic feature of the Constitution. Therefore, one of the submissions that was presented before the court today was that the Ayodhya verdict is factually incorrect insofar as its discussion on the Places of Worship Act is concerned, because apart from the fact that the act does not apply to Ayodhya, there was no occasion. It was completely based on an erroneous reading of the Allahabad High Court itself. So therefore, to answer Mr. Jindal's position, he may perhaps have slapped a few basics around in describing what is secularism. This legislation is the textbook definition of what is an anti-secular legislation, because it supports the right of one community over the other without giving sufficient reasons for the same.
Also, let me tell you, viewers, that even if the Supreme Court had decided to pronounce some sort of binding verdict on the Places of Worship Act, it couldn't have done so. It would have been in contravention of its own rulings, because in Director of Settlements, Andhra Pradesh and others versus M.R. Appa Rao and another on 20th March 2002, the Constitution unequivocally indicates that the law declared by the Supreme Court shall be binding on all courts within the territory of India. The aforesaid article empowers the Supreme Court to declare the law. It is therefore an essential function of the court to interpret a legislation. The statement of the court on matters other than law, like facts, may have no binding force, as the facts of two cases may not be